Good afternoon. My name is John O'Sullivan. I'm the president of the Danube Institute. On our behalf and on behalf of our colleagues at the European People's Party, in particular Professor Schofler, I'd like to welcome you to this occasion. I have a couple of necessary bread and butter announcements I must make right away. The first is that we are videotaping this event and it will be shown on the internet. So under the rules that now prevail, I have to tell you that if you object to this, your remaining here is evidence that you consent perhaps to being filmed in the course of questions and answers and during the lecture. Secondly, I'm very happy to acknowledge a debt of help and assistance to the European People's Party and to Professor Schofler of helping to arrange this event. It occurred from a chance conversation about other things, and we both agreed that this particular topic, namely the topic of the way in which international law has increased, is increasing, and maybe ought to be diminished, in its role of determining the way in which we live, not only in Europe, but particularly in Europe. There is obviously a great deal of contention on either side, disagreement on either side of this issue, but most people who look at it agree that since the Second World War, and particularly accelerating since 1989, the role of institutions like courts, bureaucracies, international treaties, and global bodies and international bodies like the European Union and its court system have increased in the way in which politics is governed, in ways in which country is governed and politics is decided. And the role of parliaments and elected officials and congresses has tended to retreat somewhat as a result. Some people obviously think this is a good thing, others a bad thing. It is disputed among people what it should be called. The people who tend to favor it want it to be called liberal democracy and call their opponents populists. The people who don't like it claim that liberal democracy has now become a hyphenated thing, that liberalism and democracy were both better when they ceased to be fused precisely into the same idea, and consequently, though described as populists, they maintain that they are representing genuine democracy. So this is a large topic, and we have three exceptionally distinguished lecturers to address it. Their precise distinction, I'm not going to read out to you in detail because you have their records in academic and intellectual life on your chairs. I will say just briefly a few things about each of them, but I will say this, that the fact that such a large number of people have come to hear them is a tribute to two things: their high intellectual reputations, and I have to also add the intellectual seriousness of the audience on a day like this, particularly in view of the air conditioning. So I would like, therefore, to first of all welcome Noel Malcolm. Sir Noel Malcolm is a member of what do they call it now? The endangered species. He's an Old Etonian. Old Etonians are held these days to be people who are dangerous to equality and so on. Fortunately, he was born in a more tolerant time, and as a result has been able to rise, first of all, in academic life. Secondly, in journalism, where he was a distinguished political correspondent and later foreign editor of The Spectator, which is one of the most long-lasting and arguably the most distinguished opinion magazine in the English-speaking world. He is an expert on the great political theorist Thomas Hobbes, and has recently edited his correspondence. He has written a number of other books and articles. He is at present a Fellow of All Souls, and he continues to be a person who dominates the topics in which he discusses. He was, for example, in the English-speaking world, the historian who tackled, at the time when it was absolutely vital to know more about these things, the histories of both Kosovo and Bosnia, and indeed he advised Lady Thatcher during that period. So talking about someone who has both the academic excellence, but also the political and public commitment to telling the truth about important matters when that truth itself really matters. And so today we're inviting him to address this topic, the topic of human rights, political wrongs, and international law. Sir Noel Malcolm.
Well, thank you, John. Thank you very much for that kind introduction. Many thanks to you and the Danube Institute for inviting me, to Professor Schöpflin and the EPP for making the event possible, and to everybody for coming. I'm a little embarrassed by the introduction for more than one reason, but partly because my talk is on a narrower topic than the broad panorama of debate that John sketched for you. I'm only really talking about human rights and human rights law, and I'm not waging any larger arguments here and now about internationalization and so on. But I have enough to do in the course of one lecture talking just about human rights law. John was very flattering about my academic work and so on, but I should begin by saying I'm not an academic lawyer. I have long-term interests in the history of political theory and the concept of rights, but I was asked by a think tank in London called Policy Exchange to write a pamphlet on human rights law and the concept of human rights. And I agreed to do this because it was a subject, the concept was something I'd been interested in for a long time. The actual nitty-gritty law was something I'd only seen in the way that an ordinary citizen sees it when they read reports in newspapers. So it was interesting to spend on and off the best part of a year going through a lot of the case law, the standard writings on the subject, how this law is developed, what principles it uses. I certainly educated myself. But what I wrote was meant to be a pamphlet for general readers, for concerned citizens, not simply for academics. And I say it was meant to be a pamphlet. It turned actually into a book, about 150 pages, called Human Rights and Political Wrongs. And you can view it and indeed download it for free from the website of Policy Exchange, which is why I have not brought lots of printed copies with me. It contains a lot of details, and I can't go into a lot of individual case law, for example, in this short lecture. So if you think some of my statements are a bit generalized, where's the evidence? Please look on that website, Policy Exchange, under publications, and I think you will find it. So what are human rights? Well, there are two ways to answer that question, an easy way and a difficult way, so I'll start with the easy one. The easy way to answer it is to say human rights are the rights that are listed in a number of authoritative documents. Starting with the International Declaration of Human Rights of 1948, the two international covenants that sort of flowed from that under the UN, developed in the 1960s, but most importantly for our purposes, the European Convention on Human Rights of 1950, under which we all live. This is what has generated what we all call European human rights law. As I'm sure you know, this is not EU law, this is the Council of Europe that set up the convention and which runs the court in Strasbourg where this law is judged. It's an important area of law because it has a kind of enforcement throughout the Council of Europe member states, which is 47 states in total, each one of which contributes one judge to the court. I say a kind of enforcement. There is a mechanism when a judgment goes against a country for the court to ask the Committee of Ministers of the Council of Europe to get on the case. In fact, the sort of political process there is not exactly enforcement. What makes laws change when they have been found to be in violation of European human rights law is a kind of moral and political pressure on the governments concerned that it is simply intolerable to have laws which are in violation of human rights. And this is quite a strong pressure. And in most cases, when a government has been found to have a law or a policy which violates these human rights, it is quite quick to change that law. So we're talking about a kind of moral authority here, and this is important because the effect is to override existing laws. And so this places some responsibility on the whole system to make sure that they've got it right, that they are overriding on proper grounds. Now, there's a tradition of talking about rights started by the American jurist and philosopher Ronald Dworkin, which uses the phrase rights as trumps. Trumps as in the card game, where if hearts are trumps, then even any heart at all, even the lowest one, is more powerful than the highest cards in any other suit. And his argument was rights are trumps in comparison with interests, policy interests, interests of all the other kinds that would normally dictate social policy, government policy. You can make your utilitarian calculations about costs and benefits and advantages, but if any of that turns out to be in conflict with a right, then the right wins, because rights are trumps. Now, this was a general argument, and he was thinking particularly of rights in the American system of constitutional law, not particularly about human rights. But it's a sort of model that got into the literature. It's quite an extreme view, and I will say in a moment why I think it doesn't work. But first of all, let's just look at the convention. As you probably know, the original text of the convention has 11 articles, each of which sets out a major right: the right to life, the right not to be tortured, the right not to be held in slavery, and so on, down to the right to freedom of expression, freedom of association, and so on. Those 12 key rights. Then some others were added later, after the treaty, the convention was agreed, and you can add them by agreement in what are called protocols. And over the years, there have been a number of protocols adding more important rights, such as the right to peaceful enjoyment of your private property and so on. And a typical article works like this. It will normally be stated in two parts. First, you have what we may call the pure statement of the right. So, for example, Article 8 says, everyone has the right to respect for his private and family life, his home, and his correspondence. That's it. That's the pure statement of the right. But then the second half of the article puts in what are technically known as the limitations. And this says, there shall be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. So you see a long list of the so-called limitations, in other words, factors which can be taken into account in order to permit what would otherwise appear to be a violation, well, what would otherwise be a violation of the pure right. There's an interesting philosophical question here, which I won't go into, but it's worth planting in your minds. What actually is the statement of the human right in this case? Is it just the pure right in the first half of that article, or is it the whole article taken together so that the human right itself includes an allowance for these countervailing interests or values being authorized to limit it? Well, I leave that on one side. But note that these limitations, there was quite a long list in that article, which is why I read it, but other articles include some other phrases, such as the general interest, or even the public interest. So some of this is pretty general. And the key point I want to begin by emphasizing is that when you look at the actual cases that go to the court in Strasbourg and the arguments and the final judgments, almost every case is about the balancing act between the value of the pure right and the countervailing values of these limitations, of national security, protection of health and morals, whatever they may be. So it seems to me just obvious in this case, rights are not trumps. The whole jurisprudence depends on trying to find ways of deciding whether this right is so strong that it should not be counteracted in this case by this public interest. It's a balancing act, and in almost every case that's what the judges have to do. Judges have to decide, therefore, what are the requirements of public order, the general interest, national security. And they're also having to decide what are the interests of other individuals or other groups, because they can come into this balancing act as well. And the problem, the fundamental problem, is that many of these things are inherently political issues, or at least they are in the realm of things that politics itself normally deals with. We have politicians and legislatures to decide how to pursue our national security or to what extent public order requires X or Y. So we are, with this kind of law, bringing judges necessarily into a realm of possibly political debate. And so the popular idea, which I think still is quite common in the general public's thinking about these things, the popular idea that the judges in Strasbourg or in any Supreme Court which is deciding human rights, that they are some sort of super priests of some special knowledge or sort of scientists with some pure doctrine of human rights, that we turn to them to say, oh, well, you will be able to tell us exactly what the human right is. Is a paparazzo allowed to do this but not that, because this is not a violation of human rights, but that is. It's not really a pure science that they're applying. What they're trying to do is to balance a general understanding of the right with estimates of the public value, the value in ordinary social and political terms of various other interests. So this is very different from a lot of ordinary law. It's not like the sort of technical applications of settled law that go on in a lot of other courts. It's a bit more like making political decisions, because these are decisions that are infused with values. They depend in the end on particular assumptions about what is a good life and what is good for society at large. So the two key points I wanted to start with is it's not a science. It's certainly not a pure science of human rights, because it's mixed up with all these other considerations. And secondly, because it's mixed up with them, it overlaps in many ways with what we want democratic politics to do if we believe in a democracy. And both of these points, therefore, raise some points about the special authority of human rights law. As I began by saying, it has a kind of enforcement because of the strength of its moral authority. It would be shameful not to change your laws if they've been found in violation of human rights. Why does it override ordinary law? Because it represents, obviously, very important moral values. But again, the problem is it's not just a question of making general moral judgments, saying, oh, well, that law is morally undesirable. You have to be more specific, with more specific reasoning, to talk about the moral undesirability of that particular balance being not quite the right balance between that and interests. And how specific can you be if you don't have a science, on the other hand, of these public interests, exactly how much to value them? So it's actually a very, by its nature, it's going to be an imprecise business, and I think imprecise in ways that other areas of the law are not. I don't expect any area of the law to have mathematical precision. That's a fantasy or a fallacy. But because of the nature of these policy judgments built into this area of law, I think it does have a particular kind of a problem attached to it. And as I said, democratic politics normally deals with a lot of these issues. And there is a case for saying that it's better to have democratic politics in charge of the issues that are actually very difficult to decide, where there are equally valid opinions on both sides, where reasonable people working from perfectly respectable values can come to opposing conclusions. How do we decide between them? Not by finding some super intelligent arbiter who can say, well, you're more right than that person is. One of the things we expect democratic politics to do then is to take these differences, have the debate, and reach a conclusion which is validated by the fact that it's been done democratically. The legitimacy of that validation, I think, is just an intrinsic part of what we value in democratic politics. Now, there's an obvious objection at this point, which is, what about the tyranny of the majority? Should we avoid giving important things to a parliament to decide, because this might just hand over to the tyranny of the majority? I think the question of the tyranny of the majority is a fundamental one, but I think the phrase is sometimes used rather loosely, and we need to think quite carefully about what we are implying when we when we use this in particular cases. It's often based on a very crude model of democratic politics as so-called interest aggregation, where you just do arithmetic, how many people want X and how many people want Y. And then if more people want X, then you say, well, the tyranny of the majority is that the majority gets X and the other people get Y. Most democratic politics in any serious democratic state is not reducible to that. There are serious political debates about values. This is what politics is for. And we have many examples of things being abolished, like the death penalty, when we knew that the absolute majority in the population were quite happy to keep it. So politics is more adaptive and more subtle than that. But the problem is that it's easy to say, well, what if Parliament voted to abolish freedom of speech? That's not, I mean, that would be tyranny of the majority if that just went through on a majority vote, but that's not the sort of problem that we really face. The problem we face with human rights law is about these limitations. What is national security? To what extent does one of these other things counterbalance freedom of speech? And to call the majority view in a case where you disagree with what's been decided tyranny is to suggest that there was some objective way of proving that the other view was correct and that this one has been wrongly imposed. But these are the cases where it's very difficult to find a clear objective criterion for saying that either side is correct. So it's a complicated business. The general tendency that I see today, and in the last sort of decade or two of this human rights law, has been to expand the area of the application of the human rights law into areas where I think it would be reasonable to say that a responsible democracy can make the decisions itself. And I will just give one example, which is the most famous one in the United Kingdom, whether prisoners should be allowed to vote in elections. Now, there are many liberal democracies in the world that allow this, and there are many liberal democracies in the world that forbid it. And there are some in between where it's only the prisoners on long sentences that cannot vote. It's easy to see that there are reasonable arguments on both sides. It's hard to see that one side can be proved to be right and the other wrong. That seems to me like a classic case where it's one of the jobs of a parliamentary democracy to discuss the matter seriously and then reach a decision which will be validated by the fact that it was reached by democratic means. Anyway, that's the example that has most occupied attention in my country because it was the one example, the one case on which the British government actually refused to implement the rulings of the court for many years until it reached a very sort of artificial compromise just over a year ago. So I think there is a deep problem of how this human rights law relates to democratic decision-making. Those who defend, thank you very much. Those who defend the Strasbourg system generally will turn to two features of it that they say show that it is not in conflict with the needs of democracy. One is the fact that it uses the phrase necessary in a democratic society. It has the test of necessity in a democratic society. And if you have a very good memory, you'll remember that was in the list of limitations to Article 8, which I read out earlier. There shall be no interference with the exercise of this right except in accordance with the law and necessary in a democratic society in the interests of national security, etc., etc. Well, that phrase is certainly there as a limitation in many of the articles, but the way in which it is interpreted typically by the court in Strasbourg is not to say this means that there are some issues which should be left to parliamentary decision-making. It's generally used to mean democratic society implies not a procedure, but a set of values embodied in the society of tolerance, pluralism, and so on. Now, all of that, I think, is of fundamental importance. I have no argument with the idea that democratic states should have tolerant and pluralistic values. But all I'm saying is that since this is then used actually for anti-majoritarian purposes, to say, well, you shouldn't regard the majority as having any special right to vote through a law because that might go against the pluralism of the minorities who are against that law. All I'm saying is that the presence of this clause in the human rights law does not itself mean that the law embodies a special respect for democracy. Democracy as a matter of parliamentary procedure. The other major issue they will raise is this thing called the margin of appreciation. And this is a doctrine developed by the court in Strasbourg. It's borrowed from the French appréciation, which does not mean appreciation, it's mistranslated into English. It means sort of assessment, estimating. And the argument is that national governments are allowed some margin when it comes to estimating or assessing some of the factors involved in this difficult balancing act. So when it says in the interest of the protection of public morals, well, that an individual state is allowed to have some leeway in deciding what for its country is the protection of public morals. And that's called the margin of appreciation. This is a doctrine that has developed over many years at Strasbourg, but as it's developed, it's been used in many different ways. And I've read learned monographs by academic lawyers trying to find the essential principles on which it works, and they are baffled by it. There are many variables in calculating this margin. There is no consistency, and so there is no predictability. I'll just give you one example. One key element in calculating how much margin of appreciation should be allowed by Strasbourg in a particular case is what they call the consensus of states. And this means simply how many of the 47 member states of the Council of Europe have this law or do not have this law, or have this policy, do not have this policy. So if your country is taken to court at Strasbourg for some law it has, and it's in a very small minority, and most countries do not have that law, have the opposite, this is said to narrow the margin of appreciation. But if there are many countries, then you have a wider margin of appreciation. Now that seems in itself reasonable if you're going to operate this system, and you might think that here at last there was something. I said I don't expect mathematical precision in the law, but here at last you might think there's something that is arithmetical that could be calculated. But if you look at how this has been used by the court in Strasbourg, you find there is no consistency at all. So in one important case in 2015 on same-sex marriages, 51% was enough for the judges to say there is a consensus. 51% of the 47 countries that gave a consensus. In another case, on changing the birth certificates of transsexuals, 89% was said to be not enough to form a consensus. The Irish law on abortion, which has recently been the subject of a referendum, was upheld by Strasbourg when Ireland was one of only 4 states in the whole of the Council of Europe that had such a strict anti-abortion law. So it was, there were 91% on the other side, but apparently 91% was not enough to create a consensus, although on another issue 51% was. And of course, if you're the only country to have a law, then this is counted strongly against you, and you're given very little margin of appreciation. Well, on the arithmetical model, that at least makes sense. But then I would just turn back to the phrase the tyranny of the majority and ask whether that principle is being fully respected in those cases. So, let's look at how the human rights law is applied in a little more detail. There's one fundamental, rather abstract principle which I have to talk about for a moment, which is proportionality. The basic idea is that if you're calculating this balancing act with these limitations, you say, the judges may say, well, all right, it's possible for freedom of expression to be limited for the sake of national security, for example. So a journalist cannot publish sensitive defense information. But the limitation, the way that limitation is embodied in the law must be proportional. In other words, just enough to do what is necessary to safeguard national security, and not more. Now that in itself is a very, very sensible, I would say obvious principle. But many of these balancing exercises are more complex than that. There are various different factors involved. And to say you must do just enough to satisfy this interest and that interest, but not so much that you go against that interest, it's like a sort of an equation without any clear values being put into it. How do you know what is just enough in any particular circumstances? As I said, there isn't a science of this. It's easy to see that everything depends on circumstances, but this has led to what I call in the book a cult of circumstance, where judgments say, oh, this is wrong because it didn't look closely enough at the circumstances. But it gives no guidance on what rules you would apply at the level of detail if you did look at the circumstances. I'll just give you one example which I mentioned, a British one. In Britain, if a woman in prison gives birth while in prison, she keeps the baby for a maximum of 18 months, and then it has to be handed over to foster parents because, it's good for the baby to be with its mother at the beginning, but when it's, growing older, it's not good to be brought up inside a prison. You've got to have some cut-off date, whether it's 18 months or 20 or whatever. But that was the law, 18 months. A case was brought by a woman who wanted to keep her baby longer, and this law was found to be a violation of human rights because it did not attend enough to the circumstances of the mother. And because this was in a British court, they actually gave a number of possible circumstances that would be relevant, whereas the Strasbourg court would not normally give that level of detail. But it never said how you would work the equation. Would you give more value to this aspect of the woman's background, or to that aspect of how soon she was going to be released, or to this aspect of the nature of the prison, or it put in various other factors. But if you don't know how to do the actual equation here, what does it mean to say, oh, you haven't looked closely enough at this circumstance or that? You may end up with a situation now where in different prisons, women will have very different judgments made about them, some 12 months, some 18, some 36, I don't know, but on bases that are not comparable, and where it's possible that if one is being well treated, another is being treated relatively badly. And a kind of systematic injustice can be brought in there in the name of a more precise application of justice. I just give that as an example of how talking about attending more closely to circumstances so that everything can be exactly proportional is easy to say in the abstract, but actually very, very difficult. I think in principle it raises very serious difficulties in practice. Now, the other problem I want to talk about rather briefly, it occupies a large central part of my book, is rights expansion. A general term I use, it includes rights inflation and rights proliferation, but I'll call it rights expansion. I analyze 8 different ways in which this happens in the book, and I can only talk really about one of them now. I mean, there are various reasons for rights expansion, and at an elementary level, it's not surprising that rights have expanded over the years that this court has been operating. Many new cases have been brought, different dimensions of life have appeared before it. It started with these elementary statements in a few abstract nouns in the articles. You would expect some expansion over time. But the way it expands, I think, derives in the first place from the fact that it starts with these very open-ended abstract words like private life, liberty and security of person. This is rather different from most of the other sort of areas of criminal or civil law, where when a new law comes in, it's in legal terminology that already has a big sort of background of legal theory around it and case law, and we know quite precisely what those words mean. Whereas here it's sort of opening up from 1950 onwards in a much more open-ended way. And of course, it's true to say that all laws develop, but this is a very special kind of law. This kind of law consists of interpreting the wording of a treaty, because the European Convention is a treaty, and this is treaty law, and it's subject to the basic rules of treaty law. And there are learned studies of how treaty law can evolve in meaning while the treaty is in force. The main form involves updating the meanings of specific terms, especially technical terms in the treaty, but also more generally evolving in accordance with developments in international law. Technical terms here don't really arise, but there are more general terms that can evolve in meaning. I think the word family, where it says family life, in 1950, nobody imagined that that would include a homosexual couple. Today, most people in Europe have no difficulty in assuming that that can also be described as family life and should have the protections of law. And I think that kind of development is absolutely right. But as I show in the book, I think there are many other ways in which this law has developed that go beyond what could be justified by the laws of the interpretation of treaties. And I'll just briefly give you some examples. Again, Article 8, private and family life, home and correspondence. So private life has been interpreted in one key judgment to include business activities. The word home has been interpreted to mean your office or your place of work, which it just plainly does not. In one case, it's been interpreted to mean an area of Arctic tundra where Lapps in northern Norway were grazing their reindeer. The reasoning in the home case, this was Nimitz versus Germany in 1992, which said that, this I quote from the judgment, to interpret the words private life and home as including professional or business activities and premises would be consonant with the essential object and purpose of Article 8, namely to protect the individual against arbitrary interference by public authorities. But that's not, I mean, that purpose that they read into the article is not what the article says. It doesn't say the article is there to protect against all kinds of interference by public authorities. It says it's there, as I read it out to you earlier, to guarantee respect for private and family life, home and correspondence. And then it says those are the things that public authorities should not interfere in. So this appealed to what the judges intuit to be what they call the aim or the purpose, the object of the article or the object of the whole convention. This is what is called teleological interpretation. And once you open the gates of teleology, then it's possible to develop a text like this in all sorts of new directions. We've had key judgments from Strasbourg saying that the purpose of human rights, the purpose of the convention, is to protect human dignity, psychological integrity, the development of the personality, personal autonomy, and respect for human dignity and human freedom. Now, these are huge things, all of great value. I'm not against any of them. I hope you won't be surprised to hear. But just think of it, carefully. If we say everything protected by the European Convention is to do with respect for human dignity and human freedom, that may well be true. But in simple logic, it does not follow that everything to do with respect for human dignity and human freedom is protected by the European Convention. And there is an assumption behind this that human rights have some sort of ultimate moral purpose, that everything that is morally important in human life, therefore, must ultimately be protected by human rights, and that judges are doing something good and positive when they extend the scope of the rights laid down in this convention to more things that are themselves of undoubted moral importance. But I have to repeat, the more this extension and expansion continues, the more it will begin to trespass on areas that we have normally assumed to be the business of democratic decision-making through parliaments. The trespassing, the expansion would be justified if the judges did have a science that could just prove, no, these things are of such overriding importance that you must agree they should override. But as I began by saying, they don't. So I come back to my initial question, what are human rights? And now I'll try to give the difficult answer. The difficult way of answering this is to engage in some philosophical argument about what human rights really are, where they come from, why we think they're important. And it's a strange fact that after nearly, more than 60 years of having these human rights as part of our sort of political and legal landscape, after huge mountains of books on the subject, chairs and journals and so on, to this day there is no agreed theory of what exactly they are, where they come from, how they are derived. Now, of course, you might say the same thing about morality itself. And that's absolutely true, and perhaps we shouldn't be shocked by it, but we haven't set up a special body of law called morality law, which we've then given the power to in effect, override ordinary democratic law. The standard assumption of all the various attempts, the various competing theories, the standard assumption is this is a fundamental problem of moral philosophy. They're called human rights because they're derived from something in the essential nature of humanity. So we need some process by which to examine human nature and derive from it in a reliable way the identity of these special rights and the corresponding duties that go with them. And all sorts of competing theories have developed on this, based on human rationality, autonomy, personhood, dignity, agency, or some more down-to-earth ones that just talk about basic interests, even basic needs. None of them, I'm sorry, you'll have to take my word for this, and as I said, you can read what I've said at great length. None of them, I think, has really proved its case, and certainly all the others continue to disagree with anyone that claims to have proved its case. And of course, there's a danger that if they did work, if these theories really did prove what human rights were from the ground up, from the absolute basic facts of human nature up to the heights of the theory, they might succeed too well. What I mean is they might, in fact, generate the whole of morality. I mean, most moral philosophers are trying to do something of this kind, to look at essential features of what it is to be a human being and derive morality from that. And if you get the whole of morality out of your theory, then you've done too much, because we need human rights as a very special subset. It's not every moral duty that is a human rights duty. There are plenty of morally important things that are not in the field of human rights. Gratitude to your parents is an important thing, but they're not suffering a human rights violation if you're just ungrateful to them. So some people say, well, let's have a sort of model of ascending values of important rights and duties, and then we need a threshold, some sort of cut-off point. And above that level, everything is so important that those things we'll call human rights and the corresponding duties. But how do you calculate the threshold? On what criterion do you say, well, above that line, it's human rights, below it, it's not? No theorist has, even the ones who have this model and even use the word threshold, no theorist has produced any abstract argument that will show how you would calculate where that threshold was. Another problem which is obvious, often discussed, if these are human based simply on the fact that we're human beings, then presumably they apply to all human beings always, everywhere. Let me put that the other way around, everywhere and always. The always going back to the Neolithic period. So the rights in the European Convention to a fair trial, for example, should have applied also to Neolithic humans. Theorists have struggled with this one and have found ways of finessing this problem, but it's still, in principle, I think, a problem. Anyway, I won't go on about the problems because there are so many of them, but I will, in the last 12 minutes of this talk, I will try to take out my sword and cut the Gordian knot by presenting my theory, which I've set out in this book, which I think does differ in some ways from the previous ones. My proposal is that we have to start on a different basis, not moral philosophy, but political theory. I think human rights are of vital importance, but to understand their importance, we have to think in terms of fundamental political theory, what the state is and what we want state power to do and not to do to us. And to sort of lead you into this way of looking at it, the simplest thing I can say is when you look at these human rights, they are concerned with actions of the state against us. That's the real point of them. The moral philosophy theorists build up a theory of human rights, which when they've done their work, they then apply to relations between me and John and between him and anybody else in this room, sort of, so to speak, horizontally across everybody. But when we actually use human rights, what we're concerned with is relations between us and the state. If a car thief steals my car, I may be very angry, but I will not go around saying I'm the victim of a human rights violation. But if government agents come and take my car with no good reason and with no compensation, then I do say I'm the victim of a human rights violation. Indeed, it's Protocol 1, Article 1, the right to peaceful possession of private property. Again, if my neighbor is murdered by the next neighbor, that's a terrible thing. But do we send him to court on a human rights violation charge? No, we have laws against murder. The right to life is Article 2 in the Convention, one of the most important rights, obviously, but we don't say that's a violation. But if it was a government, secret agent that climbed into his house at night and killed him because of some government program, we would most certainly say this was a human rights violation. So my key point is this is a political question. It's to do with relations between individuals and the state. And you just look at that list of human rights, that's what they're all about fundamentally. The duty on the state not to kill its people, not to torture them, not to arrest them arbitrarily, duty to let trials take place fairly, duty to let people express their opinions freely, to gather in public meetings, and so on. These are all the duties of the state vis-à-vis the people. They're the fundamental minimal requirements that we make on state power. They're mostly negative. The ones I just read out are all negative. But there are, I think, some positive ones, not so much in the European Convention, but in the international conventions, the international covenants that most countries have also signed up to, though many have not ratified one of them. For example, we now expect some basic level of welfare. That's one of the fundamental things we expect a decent state to provide for sick people, for people who can't get jobs and so on. And we would find it, I think, intolerable if the state just abandoned that whole side of its responsibilities. So that is a positive duty on states, not just a negative one. And I think we can include that quite properly in our list of human rights requirements. But note that maybe 100 years ago, we would not have required that. 100 years ago, well, about 1900, I think, if you'd asked sensible and reasonable people, is it a fundamental duty on the state to provide, this level of welfare, they would say, well, no, that's not what states do. My point is these things change over time. Our expectations and our fundamental demands on the state change over time. And this enables me to get out of that problem of whether everything applies equally to Neolithic man or to medieval people in the Middle Ages or in Ming Dynasty China. There is naturally a kind of historical, cultural relativism built into this at a deep level. My key point is that these are the conditions of the legitimacy of the state. A state which tortures us, which holds us in detention without trial, and so on, is a state that loses its legitimacy. It loses its right to govern. Now, I'm talking here about essentially, I'm talking about modern democratic states, or circumstances in which people want a democracy, even if that's not quite what they're getting. I don't think this argument is applicable to many societies in the more distant past, where people were not thinking of the state in that way at all. A little thought experiment. In 1900, if in Tibet the whole population were Buddhists, pious Buddhists who were very, very happy to be ruled by a Lama who was the incarnation of Buddha or whatever pious Buddhists believe about the Dalai Lama, it would be artificial to say, oh, well, by not giving them free elections, he was violating their human rights. I think this would be artificial. The point is, the argument I'm presenting about human rights and democracy is that human rights are an essential and structural principle of any democracy. They are the essential conditions that in a democracy we set on those who rule us. Because in a democracy or a would-be democracy, a situation in which people want to be ruled democratically, we expect government ultimately to be answerable to us and to do the fundamental things for us that we need and not to do the things that are fundamentally wrong to us. And that is the nature of democracy. We have a program of political claims on it. And that's why I think this way of looking at it is a way that must focus essentially on modern democratic systems and societies. So what are the advantages of this theory as opposed to the moral philosophy theory? Well, first of all, it gets away from that terrible requirement to demonstrate morality from the ground up. For political purposes, you don't need to have a demonstration from human nature as to why it's wrong to torture people or why it's wrong to kill people. You just need to know that it's an obvious fact that people in a democracy do not want their government to do those things to it. And it may be that there are individuals in that society who, when you ask them to analyze why they're against being killed, will give very different reasons. Ones whose ethics come from religion will have different reasons from those whose ethics are secular, or utilitarian, Kantian, whatever. This theory doesn't need to bother. It just says we take that as a political fact. Another advantage of that, therefore, is that this is appropriate for a pluralistic society where people do have plural values. And I think in some ways this is one reason why human rights has risen to such a level of importance in the way we think about ourselves and the way we talk. It gives us a language of ultimate values that we can share without assuming that, if I believe in, religious ethics, then I'm assuming that to get people to agree with me on fundamentals, they must have the same ethics, or if I'm a secular ethicist, they must be secular. We don't need that. We can accept the pluralism and say, yes, but on these fundamental givens, the values that rule our society, these are the things that we share. And I think that is valuable. I think my theory avoids the problem of saying why there's just that special level of human important rights above a threshold. The moral theorists have to have another theory to explain where they put that threshold. I don't. I'm just saying it's a political fact that there are certain fundamentals in a democratic society that people want, such that if they're not done, or if the opposite is done, they will regard the government as losing legitimacy. And I think that's a simple enough way of doing it. Another advantage, it avoids that problem of the timeless human rights being the same for all humans. As I've said, we don't need to apply these human rights to people in Neolithic Africa. And finally, it emphasizes that the whole point of human rights is bound up with democracy. They are, as I've said, essential and structural requirements of democratic rule. It's a theory that implies that wherever you have democracy, you must have human rights, and they must be treated as of fundamental importance. But this also means that since human rights have a special relationship to democracy, there's a special duty not to engage in an endless expansion of the scope of human rights law to the point where it is eroding the business of democratic decision-making itself. This is something that I think was fully understood by the original drafters in 1950. And I'd just like to end with a quotation from probably the leading figure in that process, the lawyer Pierre-Henri Dejian, when he submitted his first full report to the Council of Europe in September 1949. And he wrote, "Our committee unanimously agreed that for the moment, only those essential rights and fundamental liberties could be guaranteed, which are accepted and defined after long usage by the democratic regimes. These rights and liberties are the common denominator of our political institutions, the first triumph of democracy, but also the necessary conditions under which it operates. That is why they must be the subject of a collective guarantee." And that, I believe, was the real object and purpose, to use the teleological phrase, the real object and purpose of the European Convention of Human Rights. Thank you.
No, thank you very much indeed. I think you've given us a great deal to ponder and to raise questions with you after our next two speakers. But I'd now like to introduce Professor Andrew Brick. Professor Brick was originally the advisor on law and constitutions to the first Solidarity government. He is a professor of constitutional law at Jagiellonian University. He has had positions at great universities, both in the United States and in Europe, as well as in Poland. And he has made a special history of the relationship between Poland and its Jewish population and history. So without more ado, I'd like to introduce Professor Brick and ask him to talk to you.
Thank you very much. I'm very grateful to be here in Budapest, coming from another Eastern European country, Poland. And I listened with great attention to what Sir Malcolm said, because I'm going to approach the topic from a slightly different point of view, but nevertheless touching the same fundamental issue. What is happening to the language and to the practice of human law and human rights today? And this is a problem which, to a large extent, confronts the experience of Polish constitutionalists, Polish thinkers, and essentially, in my judgment, for all of the Europeans who came out of the communist system and who were actually longing for a universe which didn't longer existed. And this is just a fundamental issue which has to be understood. To put it in another way, we were longing for the European Union, which was created by Schuman, Adenauer, and de Gasperi, and suddenly we found ourselves in the Union which was governed and has been governed by the rebellious grandchildren. And that was a shock which to a large extent has not only been accepted by many constitutional scholars in Poland, who still think that we are talking the same language as it was talked in Europe in the 50s or in the 60s. So that's one particular problem which actually stems from that particular fascinating topic. The second issue which I would like to touch is why the list of human rights is constantly enlarging. Why essentially this particular very sensitive and very important field is to a large extent coming to a point of making itself a very unserious affair. And I'm using that word unserious in a very, of course, conscious way. If you look at the Charter of the Basic Rights of the European Union, I think it's the best illustration of that. It says all discrimination is forbidden. In other words, that is such a broad statement which can be only compared to the accusations which are thrown against Poland today by the leaders of the contemporary European Union from the West, that Poland is violating European values. When asked what European values are exactly Poland violating, they essentially cannot define them, and if essentially we are talking about concrete ideas or concrete institutions, they change the topic and say, of course, this is not what we are talking about, there's something else. In other words, we are in the field of the shifting ground, which is very difficult to define and to grasp. So the third point, which should be actually stressed in this context, is also another one. In other words, all the fundamental human rights which cannot really be realized outside of the community. In other words, do we need certain types of communities for certain particular human rights, definitely human rights, to be realized? In other words, if we do not really consider certain particular type of a community or communities as prerequisite for a creation of human rights, then we are essentially limiting the field of human rights to a very ideological field. To give you a couple of examples which I hope to illustrate in my further argument, for instance, are we going to create solidarity among people on the basis of the modern liberal rights as they are understood by contemporary establishment of the European Union or the liberal establishment in the world? Are we going to create moral duty as not actually required by law, but required by a certain disposition of character? Are we going to actually have a certain bond towards, as Sir Malcolm said, towards our parents? So essentially they are not only the people who bring up and then actually are discarded, or we are actually something else. In other words, there are many rights which cannot only be created outside of the community sphere. And if the human rights are defined as a prerequisite against such communities, and increasingly they are, then essentially we may create not the society which is operated by the human rights and the decent society, but a society extremely brutalized and extremely essentially fighting with each other. Hannah Arendt said something to the effect, when I say to you, don't do that to me, because this is against justice and what you are doing to me is not just, then this is essentially a common ground for discussion. But if you talk to me, don't do this to me because it is against my right, then we are essentially talking to each other in terms of power, in terms of whom. And in that particular language, there is no universal point of orientation towards we can actually bow our heads towards a certain thing which is higher and which can actually protect the weak. Because the strong always will justify the language in which actually they talk about rights, and which always justify the creation of a particular community as being advantageous to all, when in fact this community is advantageous to only a particular people. That is why we have to start from certain fundamental issues of political philosophy, and that is another issue. The last point, which I would like to make as an introduction, is that we are probably in the liberal society, whatever it means, very similar to the type of society which was created at the end of the Roman Empire. In other words, we have so many gods that we don't really know actually which gods to cherish, without at the same time not offending the other ones. In other words, we have no common anthropology upon which we create moral language. And in that sense, if that is really the truth, then of course, when we talk about the human rights, we have to be extremely cautious and extremely, I would say, conservative in terms of creating such a list of rights. And here I come, of course, to the question of the issue which was actually suggested to me as a leading element of my presentation, that is the increase of the role of the constitutional judges, or the judges in general, in modern liberal democracy. Are we entering a totally new phase when suddenly the talk about juristocracy or the role of the judges is no longer a kind of a rhetorical statement, but are we entering essentially a phase of liberal democracy when the judges were or are placing themselves outside of the democratic constitutional system, creating the civilization on the basis of rights, on a particular basis of a particular anthropology, and in the general view, that anthropology may be actually defined as follows. We are the harbingers of the new just civilization of humanity, and we know how to define that humanity in terms of rights. This is an extremely, extremely dangerous hubris. So, coming to a leading topic of my presentation, let me just, start that this particular dream of Platonian interpretations of a constitutional system from the very beginning of the legal development has been, of course, a dream of everyone. And suddenly, we found ourselves in a situation that the judges do really, actually, may play such a role. The late Antonin Scalia, the judge of the Supreme Court of the United States, the court which is at the same time the Constitutional Court of the United States, in his last judgment, he didn't really know about that, nomen omen, he just died after the judgment, but that was his last factual judgment, stated, this court can do anything with rights, and there is no power in the entire political system which can stop this court from doing that. Meaning, essentially, we are superpower which can dictate to other people how the society should be organized. And that is, of course, a dramatic shift from the constitutional theory as it was created both in the United States and in Europe in the 18th century. Because that system, if we may use James Madison as the father figure of that system, stated that essentially the separation of power, that is the power of the sovereign people, into separation of powers, that is particular institutions actually with particular competences, that this, of course, tripartite division of power had as its first aim and task the preservation of human freedom. In other words, but that particular, of course, separation of power can equally be destroyed if one power is going to take over the other ones. And in this particular case, he actually was thinking about judicial power as well. He was thinking about the legislative power as well. But at the same time, he stated, if there is one particular power which can block the exercise of its constitutional powers by the other, then we essentially will destroy the separation of powers. In other words, in that case, elections and the democratic will of the people will be just kind of a totally insignificant ritual. The ritual which more or less will be treated as redundant and essentially as dealing with less and less issues of significance. And that is why we have to actually begin a question. How this particular enormous extension of judicial power actually occurred? There are two levels of analysis. The first one is that, of course, it's a structural constitutional placing of that power inside of the constitutional system. But even the more important, which is actually also crucial to the understanding of what is happening in the liberal democratic world today in relation to rights, is a profound cultural anthropological change which happened in the 60s. And this might be also looked upon from another side as a change of classical liberalism to the liberal left way of looking at reality. First of all, we have to say that the traditional 19th or the beginning of the 20th century idea of Kelsian thinking, that the judges interpret the law, which is actually clear and to a large extent obvious, that this particular idea is no longer true. In other words, after Wittgenstein and after all kinds of observations by Hart, we realize that language is to a large extent a very, very spacious place. You can do whatever you want with this language, and if you want to do what you actually really want to do, then you can do it with this. And second of all, we have to say that until the 60s, the entire language of human rights in Europe was still operating within the context of the Christian anthropology. That Christian anthropology has to be understood, of course, not in confessional terms, but in exactly anthropological terms. Human dignity was to a large extent rooted in certain concepts which were not human-made, which were to a large extent imposed on the humanity and imposed and grounded in human dignity. In that sense, after the Second World War, after the catastrophe of the Second World War, that notion of human rights as grounded in natural law and the idea of universal justice was the basis to create both the European Union and to create the basic constitutional laws of the European countries. That was exactly the German constitutional law of 1949, although the notion of human dignity was for the first time used by the Irish Constitution of 1939. It was a fantastic move also to somehow preserve the anthropological content of the European civilization inside of an essentially secular setting. In other words, to stave off on the one hand the communist pretensions which tried to capture the human rights language against liberal democracy, and on the other hand, to essentially stave off the attempts of some of the European Union technocrats to capture the human rights language as a means of creating the new ideal society on the ruins of the Christian society. And this particular, let's say, founding fathers concept worked very well for some time and to a large extent created this great European civilization which we are very proud of. And then something happened in the 60s and in the 70s. In other words, the rhetoric of the universal human rights, to a large extent, was captured by the liberal left. What I mean by that is that it was, to a large extent, totally decoupled from the philosophical universal concept of political philosophy. And essentially, the ethics of human societies were going to be essentially based on rational, applicable rules, some kind of a neo-Kantian way of looking at reality, and political justice was going to be essentially defined in equal rights terms. And to a large extent, the rhetoric of human rights began to be used against the old rhetoric of human rights. And it was based on the concept which is crucial to the understanding of what happened to the human rights in my judgment. This is a liberal left concept of emancipation. In other words, of defining the reality, the existing realities of all communities, beginning from your family, to the nation state, to essentially all kinds of cultural entities. So culture itself as a kind of a structure of oppression, as a kind of a structure of unequal relations between individuals, from which individuals have to be liberated. And to a large extent, this particular emancipation culture began to dictate three fields of emancipation. The first field is the emancipation of the market, and of course it's self-defined. I am not going to actually develop that. The second one is the emancipation of the law. It means that all human relations, both private as well as social, should be based on the rights exchange. In other words, since all the other community structures are based on oppressions, we are going to liberate individual to his or her true self, some kind of state of natural being of Rousseau. And once we define that, of course, liberation in terms of enlarging rights, and once we decide that those rights are equal and not discriminating against the other, we are going at the end to create finally a good, equal, and just society. But the third element of that emancipation is even more threatening. It is the emancipation of morality. Essentially, it says there is no universal morality. There are no universal precepts of moral law, something which was, of course, before that called natural law. We are dealing with subjective perceptions of what morality is. We are going to define our moral law by ourselves. It is up to us to decide what is the content of the moral law, meaning what is the content of my human dignity. And because of that, my morality is essentially as good as your own morality. My human dignity defined in those terms is essentially the same as your humanity defined in the human dignity terms. And that means that we are talking the language of rights of preserving our autonomy of course, human dignity. And the rights are essentially a province of contestation. And that is exactly where the judges are more and more being, of course, going into and are being, to a large extent, pushed. In other words, the human rights began to be essentially treated as a vehicle of a liberation of an individual from whatever stronger communal ties. Communal in the largest possible terms, of course, also defined as a kind of cultural community. It is a fascinating idea to find out that this particular generation, which I, of course, very imprecisely call the generation of 1968, defined the entire European culture as a process of a disaster leading to Auschwitz. In other words, the European culture has been essentially responsible in total for Auschwitz. And from now on, we are going to liberate ourselves not only against Auschwitz and against particular historical conditions which created Auschwitz, but we are going essentially to liberate ourselves from everything in Europe and European heritage which actually were necessary conditions for creating such things as Auschwitz, or in case of Germany, in case of Britain, France, Italy, or Dutch colonialism and other horrible things from the past. Meaning, we are going to essentially liberate ourselves from everything we have created. And where are we going to start with? Well, we are going to start from abstractions. We are going to start from equal rights of individuals who are going to liberate ourselves from all communities which created conditions for the creation of that horror during the Second World War. And this particular concept of global human rights were going, of course, to be exported, and to be exported through all kinds of international rules and international laws. As a condition of that human dignity as being a precondition of a human right, and thus a precondition of non-discrimination, and thus a precondition of equality per se, is essentially a concept of toleration. A concept of toleration today is a perversion of the former, of course, concept of toleration. In other words, this is kind of a concept which means that we have to accept everything without any judgment, that we cannot really discuss any moral worth of a particular behavior, that we cannot really, as a community, decide how we are going to bring up our children, how we are going to shape their particular well-being, that this is to a large extent a certain concept that everybody has a right to be everybody and demand from everybody else actually the preservation of that particular vision of life. And this is to a large extent a global project. I remember how I was shocked when I realized that Amnesty International, which was, and this is just one example, not necessarily very relevant to what I say, but it is also important in this context. When I realized that Amnesty International, which by the opposition movements in Eastern Europe was actually considered kind of a sacred organization fighting for human rights against the oppression of the communist state, suddenly put into its manifesto the principles of its operations as human rights abortion and as human rights homosexual marriage. It is not a question whether abortion or homosexual marriage cannot well be recognized by a particular community. It doesn't really concern me over here. It means that suddenly certain particular fundamental institutions which define not a right but a concept of a life in which you have to live with consequences for many other institutions and many other ways of life, that suddenly they were actually taken out of the political discussion, moral discussion, and put into the province of inviolable human rights. In other words, outside of the discussion. And because they are human rights, the province of those human rights are the judges. And this process of emancipation, which actually creates an individual as creating rights on the basis of individual human dignity as defined by himself, is what is happening to the human rights and what is happening to the international organization, considering that particular anthropology as essentially the only one, monopolistic one, to the creation of a decent society. For someone who is coming from the ideological Eastern Communist Europe, that idea gives me shivers. And this is something which actually I consider to be a kind of a perversion of this particular ideology of a venerable and extremely important human rights subject. Let me finish with the final observation. The end of this particular anthropology as defined by the language of rights and then realized through particular institutions, especially judges of the tribunals, is to create not a decent democratic society, but to create a just society defined by those who actually know how a human being should be defined at the most deeper anthropological sense. This is an ideology project. This is the project which is essentially threatening human freedom in the most fundamental sense. And in that sense, I think that this particular discussion about the human rights today and what happened to them and how can they be actually saved against those who captured those rights for their own ideological aims is the most crucial task of the European Union, if the European Union is going still to be a great community of equal nations and of equal free people. Thank you very much.
Thank you. Thank you very much, Professor. We had two very powerful and I think complementary lectures on this topic. I now invite George Schofler, who is well known here. Of course, George Schofler was born in Hungary, but lived from 1950 to after the 2000s, I think, in Britain, where he inhabited many of the centres of excellence and influence in British life, such as the BBC and the London School of Economics, of which he is now Emeritus Professor of Politics. He has since returned to Hungary, which he now represents at the European Parliament, and of course is a leading figure on the right in terms of ideas in Hungarian politics. George, thank you for helping to set this up, and I look forward to what you have to say.
Well, thank you, John. Pleasure to be here. Delighted to be able to share this afternoon. Mindenkit szeretettel köszöntök természetesen. This is an English-speaking afternoon, so I won't try any of the other 22 languages of the European Union. I found the two previous speakers extremely stimulating, and I shall take away from Noel teleological interpretation, and from Andrzej I will take away the rebellious grandchildren of Schumann, Adenauer, de Gasperi, and others, with whom, of course, I spend much of my time. And I live this with a certain ironic detachment. And some of what I have to say, obviously, is derived from my experience in the European Parliament, where I have now been for 14 years. It's a very interesting turn in one's life to be a political theorist and then to become a political practitioner. Very often the theory and the practice are really rather a long way from one another. Now, where I want to start, I think, is very much where Noel Malcolm began, liberal internationalism at the international level. In other words, a system of law, regulation, which impacts, certainly in the European sphere, on the state and effectively reduces their sovereignty. The idea of state sovereignty is now, I think, much weaker if you're a member of the European Union and if you're a member of the Council of Europe than, let's say, half a century ago. Oh, I should add here that a very long time ago, I did do law. I have a very rusty legal qualification from a country, which is a very small country, which has a legal system of its own, namely Scotland, which at least has the advantage of combining Roman law and common law. So to some extent, I'm not wholly unfamiliar with these categories. Now, what I want to suggest to you that this area that we're talking about, liberal internationalism, governance and sovereignty, is part of a much wider transformation of democracy. I think when I was young, the idea of democracy could just about be reduced to the idea of rule of consent, the exercise of political power by the consent of the governed. Now, I think this is no longer the case. What I see, and this is a dynamic process, and I want to stress that, is the transformation of democracy through a growing depoliticization. What I mean by this is growing areas where political decisions are not taken by the consent of the governed, but by all sorts of other political or other bodies which are not accountable. Again, at the heart of democracy, as far as I'm concerned, is accountability, transparency, feedback, issues of this kind. If anybody is particularly interested in this area and this depoliticization, have a look at the work of Chantal Mouffe, who, by the way, is very well to the left of me. But in this, I think we agree. She's Belgian, but has worked in Britain most of her life. I find her work extremely interesting. This reduction in the power of elected bodies, of legislatures, which I think has become a part of democracy, has also been charted by a Canadian writer called Donald Savoy, whose works I commend to your attention. In Savoy's case, it takes it in a particular direction. It says, don't be surprised at the decline in participation on the part of voters. Power is no longer in the hands of legislatures, which I think is a very interesting argument. Correspondingly to this decline in the power of legislatures, we have an increase in the power of non-elected bodies. In no particular order, technocracy. Technocracy, of course, is in a sense expert governance with its own meta-language, which is almost invariably structured around the proposition, there is no alternative. John will remember Tina, Mrs. Thatcher's words, there is no alternative. But the way in which the technocratic argument is made is, we know best, don't argue with us, we've already done the thinking, or whatever. Very difficult to call to account. The level of accountability is really not very high. I mean, think about it, there's a great deal of literature on this, notably management literature, of managerial decisions with catastrophic consequences, no accountability. Not much happens. Private sector to some degree, yes. State sector, really rather less so until the government in question happens to lose power, which does occasionally happen. Economic actors, I could spend considerable time talking about this. I think global economic actors have enormous power. And here there's a particular area that I want to highlight, which is obviously relevant to what is happening in Hungary at the moment. Money from one country being transferred to another country for particular political purposes. For example, the support of civil society. Now, much of what I hear among my colleagues in Brussels is this: what the Hungarian government is doing is absolutely terrible. Who'll stop Soros talk, but they don't seem to be aware that something very similar is happening from money from Russia, money from China, money from the Middle East, I don't know where else. There's enormous amounts of money washing around the world. And much of it is, not all of it, but much of it is really beyond the control of any single jurisdiction. Money has an autonomous freedom, quality, which is part of globalization. Consequently, the idea of state sovereignty is in that sense inherently weaker because states are permeable from outside in the ways that I have suggested. Central banks, very interesting. The book which has just been published in English by Paul Tucker, I don't remember the title, but he basically makes this argument that central banks now have an independence in practically every EU country. It's a necessary condition if you want to join the Eurozone, with minimal accountability. And this is seen as desirable by much of the political elite because it means that central banks can ensure the security of capital. The interesting exception, by the way, is Sweden. The reason why Sweden doesn't join the Eurozone, is technically a treaty obligation, is that their central bank is not completely independent. So they always say, I'm sorry, we can't join the Eurozone because the central bank is not independent. Well, yes, it's the Swedish way of doing things. There was a referendum in Sweden about 15 years ago whether or not Sweden should join the euro, and the answer was no. And this is the way in which they avoid the treaty obligation, if you like. Well, NGOs are a fascinating phenomenon. I think the power of NGOs is increasing. And their accountability is very weak. They represent society. They say, we are civil society. But how, when was an NGO last elected? I have had dealings with NGOs in Brussels. They don't like being called to account. They don't like transparency. And when we say to them, look, why on earth shouldn't you be transparent about your dealings? They mumble things and look out of the window. Very, very interesting. They exercise power without accountability. I have to say I don't find this compatible with what I regard as the basic requirements of democracy. Lobbies, very, very similar. We try to set up register of lobbyists and so on. Technically, there's supposed to be a footprint of every time I meet a lobbyist, I'm supposed to do something. It's not compulsory, it's voluntary. And finally, in my list is judiciary. And here I want, others have mentioned this, I want to myself also to use the word which has gained currency. The word is juristocracy. Now, as a matter of fact, if I want to be pedantic, I don't like this word because it's mixing Latin and Greek. The word should be kritarchy, but the term juristocracy has taken off, so I guess I don't have a choice. This has now got a very considerable literature. Some of it is in Hungarian. Béla Pokol, whose name is known to you, has a book called The Juristokratikus Állam. I think it's available in English as well. The Juristocratic State. I think you can download it gratis, free gratis, on the internet. And it summarizes much of the Anglo-Saxon and German language argument. Other authors have written about this, Alex Stone-Sweet and Ran Hirschel. Hirschel is Canadian. Very, very interesting. Basically, their argument is that there's been a growth, a steady increase in the powers of judges, which has diminished the powers of legislatures. There's been a tilting. And this, I think, is favored by the international liberal elite because they reckon that judges take the right kinds of decisions, which, of course, raises a number of very difficult issues, both at the domestic and the international level. The international level, Lowell referred to the European Court of Human Justice in Strasbourg. My experience, of course, is with the Luxembourg Court, the European Court of Justice. Don't confuse these two. They are different. And it raises a question in terms of legal theory of where is supreme power? It's the Kelsenian Grundnorm, the basic norm in any one particular legal political system. It's very difficult to say. And secondly, it raises the problem, again, the technical term from German law, the Stufenordnung, the different layers of legality. And the problem, as I see, is this, that there is the EU level of legality, which intervenes in the domestic levels of legality, because in certain circumstances, the judgments of the European Court of Justice, the Luxembourg Court, are directly applicable, not just in the area that Lowell mentioned of human rights and so on, but environmental legislation, let us say. I'm not saying it's bad, I'm not saying it's undesirable, I'm simply saying it's there. Do we now actually have two sets of basic norms? And I think the answer is probably yes, which means there is a contest for which is the higher norm, that of the domestic legislator, that of the European Union. Very difficult to say, or there is confusion and I think also friction between the two, which actually leads me to a very interesting, very difficult question, constitutional identity. The German Constitutional Court, the Bundesverfassungsgericht, clearly states that Germany has a very particular constitutional identity. The Hungarian Constitutional Court has said something very similar. And this raises the question of how much sovereignty has been transferred from the member states to Brussels. I'm using the symbolic Brussels. And here I want to read a little bit of the treaty to you, which I have on my telephone. Quite probably, I'm the only person in the room who keeps the Treaty of Lisbon on their mobile phone. Article 4 Section 1, in accordance with Article 5, competences not conferred upon the Union in the treaties remain with the member states. I think it's very clear. And then Article 5, again, Section 1, the limits of Union competences are governed by the principle of conferral. The use of Union competences is governed by the principles of subsidiarity and proportionality. This sounds very nice. I suspect that the interpretation that is where the devil lies, that the way in which the Luxembourg court has interpreted these tends to narrow the space within which the basic norm of any one member state is actually to be exercised. So this raises the question of how far should judicial activism go? I don't have an answer, I'm simply raising the question. And secondly, if we're talking about democracy, do judges exercise self-limitation? Well, the answer is some do, some don't. I think on the whole, if we look at the Hungarian experience, back in the 90s, you will all remember the invisible constitution, a láthatatlan alkotmány. That was, I think, a very clear case of judicial activism. Since the new constitution, has been, I think, a recuperation of some of its powers by the legislature, and judicial activism has shrunk. It's still there, but it's nothing like as far-reaching as I think Lowell was talking about, and I think we see in Luxembourg to some degree. The German Constitutional Court has in effect said, you know, we're the most important institution in Germany. They sort of override the German parliament, the Bundestag, on occasion. Very, very interesting. And there is the potential, it's only a potential, for a conflict between the Luxembourg court and any one constitutional court of a member state, except for those member states which don't have one. But luckily the United Kingdom is about to leave us, so that problem won't arise. There's no constitutional court in the United, well, there's no constitution to speak of, so how can you have a constitutional court? As I said, I grew up in Scotland, and people in Scotland will tell you that the Treaty of Union of 1707 actually is the constitution, but very, very few people accept this. So, is there judicial self-limitation? And I think the answer to that is it's really rather varied. I'm very much inclined to agree with what I think both the previous speakers either said explicitly or implicitly, that no judiciary can be wholly neutral ideologically. I think that every judiciary to some degree is the captive of the world in which it lives. I do remember reading a long time ago about Roscoe Pound, who argued along this. He was an American jurist in 20s, 30s, and I think 40s. I'm not sure when he died. In this context, by the way, the European Union Commission is the guardian of the treaties, but I'm not sure whether it exercises this guardianship with neutrality. And it's very difficult to call to account. My encounters with the Commission, which are regular, make it very clear, is that they adopt the same set of liberal international norms as the norms of Europe that we've been talking about, from which they cannot be shifted. So in a sense, what I think has happened, and again others have made reference to this, is that we no longer talk about democracy, we talk about liberal democracy as if these two terms were one and the same thing, and as if liberalism had a monopoly over democracy. Well, when I was young, there was still a thing called social democracy. Conservatism was a part of democracy, Christian democracy. Why not just democracy? Well, because I think the answer is evident. I don't need to spell it out. So, in a sense, given this decline in the neutrality, which is always an aspiration, it's never perfect, and the rise in both ideological and logocratic power of liberalism, what we have is the rule of law, legality, but with diminishing legitimacy. The legitimacy of the legal order in Europe, whether that's Luxembourg or certain member states, or indeed Strasbourg, is extremely dangerous because where the legitimacy is declining, then you have alternative political movements which question the legality. And at that point, we have a serious problem of where do we go? The Dutch Prime Minister, Mark Rutte, gave a speech in Strasbourg very recently, about a week ago, and he used an expression I hadn't heard before. Trust arrives on foot and leaves on horseback. I asked Dutch friends if this is really true, if this statement really does it. He said, yes, it does. What I think he was getting at is that it's very easy to lose legitimacy. And I think one of the primary means by which any institution, anybody with power, loses legitimacy and trust is if they are inconsistent. A double standard. A double standard is disastrous in any democracy based on the rule of law. So, a couple more thoughts on all of this. My own reading of the world that we are living in is that this liberal project, that of converting Europe, and indeed the whole of the world, into this particular iteration of liberalism, I hasten to add that I think it's a very long way from John Stuart Mill or Tocqueville or any of the other great liberal writers of the 19th century, Isaiah Berlin as well. So this has become the ideology of a particular social stratum. David Goodhart in his book, The Road to Somewhere, says it's about 25% of the population in the United Kingdom. Another 15-20% are neutral, the rest are uneasy, hostile, whatever. I think in Central Europe, it's just a guess on my part, it's about 10%. I don't think it exceeds 10% who've bought the liberal package. And it's all to do with the knowledge-based industries, the mobile, global elite, those who basically approve of Hillary Clinton referring to her voters as a basket of deplorables. I must say, I cannot see how a politician can refer to her voters or his voters in these terms, and still expect to be elected, but okay. So what we have, what I think this liberal experiment of the last 20, 25 years has done, is to have created an extraordinary inequality. The liberation of global capital, the footloose quality of global capital, and we see the inequality, a material inequality, but I think is worse, status inequality. That those who have the good fortune to have higher education ascribe status, high status to themselves, low status to them, and you also have assortative mating, that this stratum marries within itself, which means it's becoming hereditary, which means that social mobility is slowing down. It's a dangerous situation, I think, in any society. I'm not going to say this is going to lead to revolution. I'm a respectable conservative, so I don't believe in revolution. But still, I think it's something that we should be aware of, because I can see an upsurge. Resentment. I think actually status inequality is worse than material inequality, because that's to do with human dignity, which we've talked a little bit about. My final thought is about Central Europe. We are on the periphery. My experience of the last 14 years in Brussels is that, well, we started out being called the new member state. And my colleague Thomas Deutsch on one occasion said, you know, a pair of shoes is not new after 9 years, but a member state quite evidently is. And it was in 2014 when Jean-Claude Juncker came to the EPP, European People's Party, and I said to him, well, how much longer are we going to be new member states? And he didn't give me an answer, but then the next time he made a speech, he said, there aren't any new member states or old member states, there are just member states. However, I think on the balance, our status, I use that word advisedly, is a little bit lower than that of the EU 15 or EU 14, above all the founding states, the original 6. And this, of course, is an ancient topos. It goes back to the 18th century. If you haven't read Larry Wolff's book on this, you should. It's very, very interesting, that basically the Illuminés, the French Enlightenment, constructed a barbaric other. We are the enlightened people, and you lot out there, in other words, we here in Hungary or the Poles or Czechs slightly less so. We are barbarian others, we are hairy barbarians. That, I think, has never completely disappeared from Western thought. They don't take our voice, our wishes, our aspirations as having of equal value to theirs. So when in the last 3 or 4 years the Visegrad countries have stood up and said, well, actually, we think it should be like this, and this, immigration has obviously been the big issue, it's somehow not seen as fully legitimate among the EU 15 or 14. And my very final thought is to quote Milan Kundera, Czech novelist, who somewhere in his writing, I think I can probably find it in my computer if anybody really wants to know where it is, once defined Central Europe as Europe's early warning system. And I think he's very, very right. If you look at the developments in Central Europe, the rise of what the left calls populism precedes what happened in the West. There are very good sociological reasons why this should be. Structures are different and so on. And we would say, look, be careful, because if you're not careful, this is what will happen to you. Nobody pays a blind bit of attention. It's so annoying to be right ahead of one's time. Thank you very much.
Ladies and gentlemen, we're supposed to end at 6, which we have now reached. I was wondering if I could get an indication from the actual organisers as opposed to me, whether we can extend this discussion for another 15 minutes? Okay. Well, yes. Now, you've had 3 extremely provocative and thoughtful speeches, and lectures, and I would like now to invite you to ask questions. You can direct them to everybody or to a particular person, and I should say that we have a distinguished audience as well as a distinguished panel, insofar as we have an ambassador, a former Hungarian ambassador to the UN, Human Rights Group, and we've had several ambassadors in the room, and we have a Constitutional Court judge too. So would anyone like to ask the first question? Yes, the gentleman over there.
What I would like to ask, we talked about this utopianism, which was very throughout the ages in Europe, the last centuries, and I think was part responsible for the totalitarianism and other things, developments in the 19th century. This is, of course, man-made, and I wonder if the elite in West see the potential conflict with the radical Islam, who, of course, recognize only the Quran as the only authority, and do they see that their ideas and everything just will never can never win against the radical Islam if they keep this up? Thank you.
Is that addressed to anyone in particular? Well,
Well, let me start with the true history of the Indonesian people coming as immigrants to Holland several years ago, and the Dutch government prepared a tape for them to inform them about the country to which they were coming. And on this 5-minute, I think, presentation, there was a glimpse of Parliament. There was kind of a street, the university from a distance, naked, topless women in the beach, homosexual marriage, tulips, and the windmills. And one of the imams, who was part of that immigration, looked at one of the intellectuals of in the Dutch government and said, okay, you are inviting it to a country and you want us to assimilate. What exactly are we going to assimilate to? Because I thought, coming to you, that Holland is essentially great European culture, great universities, Shakespeare, in other words, common law, great European tradition. And you are essentially showing us that you are a civilization which doesn't offer us anything worthy of assimilation. So it seems to me that the question of Islam in the European context is less to do with Islam itself as with the European culture. Europe doesn't know any longer what it wants to believe in and what it wants to defend to. Moreover, it doesn't have, it seems, guts to defend what it wants to defend. And this is a psychological problem or metaphysical problem. In that sense, Eastern European countries, in that sense, are much more aware that there are certain things which are worth defending and which are worth sacrificing something for. So that's a very general answer to that very complicated issue. It is characteristic that the French have a problem with the Islamic population since the 20s. And they have never had any problem with the Islamic population until the 70s and the 80s. It's not only a question of scale, it's a question of a redefinition of your own culture as a kind of a culture which is essentially no man's culture, the culture for humanity. And if you do this, essentially a stronger culture which is very identity obsessed will have no I would say, object of confrontation. It will go into a mist. And that, in my judgment, is the major problem of Islam. Not terrorism and not things which are essentially auxiliary to that issue.
Could I add something?
Yes, absolutely.
Yes, if I might add something to this, 2 points. First of all, you may or may not be familiar with the concept of jahiliyyah. Jahiliyyah is basically wrongness. Originally, it was the doctrine of describing everything before the coming of the Prophet. Today, it has been extended primarily by Sayyid Qutb, to some extent Maududi, to everything which is non-Islam. It's error, but actually it's also sinful. It's haram. And secondly, the sociological point is that the Islamic incomers to Europe come from Islamic practices which have long historical roots, which actually in many ways dilute the radicalism of Islam, including the Ummah. When they come to Europe, these local traditions are absent, which means the Islam that they can develop is potentially, and in some cases actually, the most radical interpretation of Islam possible. So some of this Islamic radicalism, not all, exists in Europe, or I suppose the United States or Canada, simply because the local Islamic traditions don't exist here.
Thank you. Next question. Yes, absolutely, no. Sorry.
Yes, I'd just like to add something too. And the question was about radical Islam. And, there's a huge literature on possible policies of dealing with radical Islam, which will be generally familiar. But I believe in the long term, the answer to radical Islam consists of the non-radical Muslims. This is a problem that Islam will solve, I hope, itself. And I don't believe that non-radical Muslims pose any threat to our values or society. There's always a problem with mass immigration with the sheer numerical effect of very large numbers of people coming from a very different culture. There are ways of dealing with that, but there may be sort of absolute numerical limits. But I don't see non-radical Muslims as any more problematic than Orthodox Jews, who again have a very different set of basic values based ultimately on theological principles. I'm a little nervous of getting into a position. I mean, I'm very sympathetic to what Professor Brick said about, we don't want to get into a position where some dogmatic and sort of deliberately destructive, radical agenda takes over all our values and so on. But equally, I don't think it's realistic to talk as if there is some counter position representing traditional values that can equally take over our society. It's just too late for that. We live in a very plural world and a plural society. And one of the points I was trying to make in my talk was that the value of human rights properly understood is that they can be accepted on a pluralistic basis. I assure you that non-radical Muslims will be just as keen not to have their government torture them or put them in jail without trial and so on. And just generally, I think there's a danger of becoming too nostalgic for a world of sort of monolithic values that we've just lost. The liberal principle that we don't want to be subject to any obligations that are not ones we have directly consented to, which is the most attractive feature of the sort of general liberal view, it's something that all of us in our daily lives actually follow and rather like. The difference is simply, do you impose a sort of general ideological view that makes that the test of everything and knocks down any other values that have different derivations? Or do you realize that in a modern society, you accept the principle of consent, but you allow it to coexist with the fact that values come from other things, that there are still serious religious values, values of attachment to place, and so on? It's getting the balance between those things, I think, that is the real task of what I would call liberal conservatives today. And I don't see that as a contradiction at all. I think it's an essential position to have.
Good. Thank you. Sorry, the gentleman.
Well, may I just,
I'm sorry. Perhaps you can make the point you want to make in response.
Well,
So
I have no qualms with what Sir Malcolm said. Essentially, we are living in a modern society. But it seems to me that you have to prove that reformation inside of Islam is possible and will happen. In other words, that's, of course, kind of a hope which so far has not materialized. But something more is important. Maybe you are right, but that doesn't really relieve the politicians from defining the political moment which might either speed it up or essentially hinder that. And if you miss that political movement and the political movement of prudence, you may essentially not being able to create conditions in which maybe the reformist Islam might essentially emerge. In that sense, for instance, opening of the European borders to absolutely unlimited immigration was the political move which to a large extent was against any rule of rationality of politics, and which might destroy any civilized means of essentially conducting the issue how to accommodate Islam into the European. So essentially, politics should be placed at the center of contemporary Europe as on equal part as, for instance, human rights or essentially the general ideas about modern society.
No, can I just say, is this in part a question of numbers and time? In other words, the absorptive capacity of a civilization to accept larger numbers or shorter numbers, and in order to incorporate them with as little conflict as possible.
Well, obviously numbers make a difference, again, there is a large, well-known debate about the spectrum that ranges from so-called integration to so-called assimilation. But we have seen quite large numbers enter our societies in the past. I think if you'd looked at some of the Orthodox Jews stepping off the ships in the 1890s, 1900s, you would have thought these people are very, very different from us, and it's hard to imagine how they will be integrated into our society. And some of them still look different several generations later. But they are in our society. I mean, the problem is, in this case, the parallel doesn't go all the way because there wasn't the equivalent of radical Islamism. There wasn't radical Judaism involving terrorist attacks. And, of course, that's another dimension of it. But I was talking about ordinary Muslims. And this question of whether Islam is not susceptible of reformation, well, Islam has, in the interpretation of Islamic doctrine has changed over time, but the ones who haven't had the Reformation in many parts of the Islamic world just lead very ordinary lives similar to those of, say, pious Catholics in southern Italy, where religion is just something they're brought up with. It's a matter of daily or weekly things they do and things on an annual cycle. It's just part of a way of life. And so without undergoing this Reformation, which I think is a rather sort of westernizing conceptual template to put onto Islam, they've managed to live for many, many generations with a kind of ordinary Islam that isn't in itself intolerant of others and needn't be.
Yes, of course, in addition to the Reformation, Christianity had the Counter-Reformation too. The question, what I've got to do is take one more question, then I'm going to ask the three of you to respond to it, but also to make any other points that you wish to.
I just want to make one very brief point, which is relevant to what Noel said. I was in Stamford Hill very recently, I think a year or two ago. This is the Orthodox Jewish area in London. I was standing at the bus stop, and there were two little girls aged maybe 5 or 6. This is a very safe area of London. And they were speaking Yiddish to each other. They're obviously born there. I suppose they spoke English, but clearly their first language was Yiddish, Orthodox Jews, and why not?
Gentleman here.
Yep. Thank you. I would like to address a question to Sir Noel Malcolm, because he mentioned the specific case of human rights violation when it is committed by a person who is actually working for state security. And either is a private matter or in a private or public or between public entities. Sometimes it happens, and very often the case that they are using people as a second job, to either investigate or interfere of business affairs. And in some cases, they actually destroying family life. They are using definitely illegal means, to validate their will and their influence. So, what do you think? What can be done? How to make justice and how to enforce justice when after the report or request for investigation, it is rejected because it falls under state secrecy? Thank you.
Well, you've made one key point, which is that a request for investigation has been rejected, and that is essential in sort of leading to the next step, because under European human rights procedures, you have first to go through the national remedies or to try to exhaust the national remedies. But if national remedies are not forthcoming and there is a good prima facie case that there is a violation of, in this case, Article 8, the right to respect for family life, then you take a case to Strasbourg. I can't think of an exactly parallel case, but it seems to me, from the general description you've given, this is exactly what would fall under that area of the jurisprudence of the Strasbourg Court.
And are there any, would you like to make any final comments at all about I mean, that's the last question, so right. Anything else? No?
Well, just in generalities, I made a rather general comment that reflected, as he was aware, on some of Professor Birk's presentation. Just one general comment on George Schöpflin's presentation. I too think democracy is of fundamental importance, and I do think that it has been eroded in some ways, significant ways, by membership of the EU, which is why I personally voted to leave the EU. That was simply on the question of democracy. But at the same time, I don't think that democracy has to be sort of just directly executed all the time. I'm sure Professor Schöpflin doesn't think so either, but I'm not bothered in principle by the fact that central banks are independent. What makes them independent? It's national legislation setting up a statute which says they will have these powers and responsibilities and they will be independent in this way. Ultimately, that can be changed by another piece of national legislation. I'm not bothered by the fact that the European Court of Human Rights does these things. It's there under a treaty obligation which each country has signed up to, and we have freely agreed to put ourselves under it in these areas. What bothers me is the way that it has, I think, misread and overexpanded its powers. And I'm not bothered by courts generally having powers that are independent. On the contrary, I do not want directly elected judges. I want courts to have full independence. But just going back to my subject, the European Court of Human Rights, having spent a lot of time reading the case law and reading about how this court works, I honestly don't think that we are looking there at a case of a sort of liberal elite taking over and supplanting the values. You have quite eminent judges coming from national judicial services and sitting on that court, well, some more eminent than others, but on every important case there are very solid judges from serious countries with a long history of the rule of law. They're just doing what they think the task requires them to do, which is to protect vulnerable people. But given the way that the whole body of law has developed, they see this as a very open-ended task where they can find more and more ways of extending the scope of these rights to protect more and more vulnerable people. And on any individual judgment, you might well sit there and think, well, that produced some wonderful result for people who were very vulnerable, who were being oppressed and so on. But you have to stand back and say, but should this extension of the law, which goes beyond anything in the text of the law, should this be the way that this law is interpreted? You know, if it's a treaty, we are bound by what we actually agreed, and we can't just treat it as a sort of wish list of things that we would like to happen more generally. That's my problem with it. I don't see this as part of a liberal elite taking over the world. I recognize many of the things that have been referred to in terms of a sort of rather aggressive and triumphalist agenda in some quarters, but I don't see this sort of institution as falling under that as a direct example. I just think that the law itself, the interpretation of it, has got out of hand.
Good. Professor Brake?
Well,
Absolutely.
I wouldn't be so much, I would say, counting on a restraint during interpretations. In 1717, Bishop Hoadley said to an English king, who has the power of interpretation, has a power to legislate. It seems to me that more and more issues are being just, pushed into this particular gray area of interpretation which the courts are dealing. The second observation is, maybe I didn't just understand that question of yours in relation to your answer, but I would be very, very willing if essentially a question of me and my bringing up my children be decided by the European Court of Justice in the final, as a final judge of a very delicate and a very important issue. That touches upon your very fundamental idea you mentioned over here. In other words, there has to be a certain understanding what we mean by democracy. And there has to be a certain understanding that democracy is to essentially guard human communities in certain respects from the power of the state. And the judges, to a large extent, represent the power of the state, not necessarily the power of independent guardians of the sea of human rights, which actually are directed against the people. The rebellion against that shape of liberal democracy, which is not only a case in Europe, because that's in Eastern Europe, that's also Brexit, that's Italy, that's the United States, is essentially the rebellion of people who realize that they are being robbed of certain fundamental power to shape their own personal lives, and they are helpless to essentially influence their lives. In other words, it's a breakdown of fundamental solidarity, which is not a question of economic inequality. It's a question of essentially the strong taking responsibility for the weak. We are never going to be in the world in which everybody has the same or everybody has the actual same power. But essentially, the strong has suddenly abandoned the responsibility for their own societies. In other words, you have to love something first to love humanity. If you start from loving humanity and shape your own life according to that image, essentially you may end up by imposing your own image of what it means to be human on other people. So that's my final comment.
Thank you. And finally, George Shaflin.
Thank you very much. 2 points. To you, Noel, vulnerable people was the term you used. The problem is who defines what constitutes a vulnerable person or a vulnerable group. Secondly, I entirely agree with the interpretation problems are a dynamic one. And there seems to be, that's where the problem of self-limitation comes in. I can't see any countervailing force or power or, I don't know, moral suasion that actually says, look, I think you've gone too far. This interpretation will no longer be digestible, let's say, by the bulk of the people. That's why, to some extent, not 100%, I am in favor of strict construction, which is a well-established, well-recognized form of legal construction that you take the words at the simplest meaning. This goes back a long time in both English and actually American practice as well. The second point I want to make, this is the history point that you made, that everything basically is about Auschwitz. Now, I think this is nonsense. You really can't reduce European history to a single focal point, which is Auschwitz, which of course is the absolute evil. Nobody ever actually said, okay, we're going to say Auschwitz is absolute evil. It just sort of emerged. How did we come here? Well, it sort of, it happened. And it seems to me, by the way, that if you have absolute evil, it also raises the question, well, what is absolute good? Which then takes us back into a difficult issue of theology, which is not a part of this liberal discourse. What I do see, it's the abuse of history. I could quote Arendt here as well. Reading history backwards, for example, or Sir Karl Popper, historicism, that history is entrusted or endowed with a meaning. You can take that back to Hegel if you want to. What I find, more or less on an everyday basis, the expression which I'm sure you all have come across is being on the wrong side of history. The wrong side of history? Does history have sides? Does it also have a top and a bottom? What is the shape of history? I mean, it's a metaphor, but people take it very, very seriously. And they say to me, but be careful, you'll be on the wrong side of history. I say, there's no such thing. History doesn't have sides. History is a multiple set of happenings and the interpretation of those happenings. What I do see, not many people I think would call it this, I think there's a certain idea of historical inevitability in some of so-called liberal thinking. It's not wholly unlike the communist doctrine of historical inevitability, but then probably all doctrines of historical inevitability share a certain common ancestor. At the same time, inevitably, because the historical inevitability doesn't really quite correspond to what is happening on the ground, so apart from me, nobody's calling it that. I think we're looking at something which can be called liberal false consciousness, which for me is the existence of national identity. National identities, as far back as I can remember, my colleagues have been saying, why do you ever bother to study that? It's disappearing. And I said, well, actually, the answer is no. I spent a lot of time at the London School of Economics working together with late Anthony Smith, developing the ideas of theories of nationhood and so on and so forth. And I think one of the things that we have to accept, liberals or really ought to accept, is that no, national identity will persist for the foreseeable future.
Well, I think following your remarks, George, on inevitability, I should quote the remark of a great liberal, John Maynard Keynes, who said, "The unexpected always happens, the inevitable never." So I want to thank all three speakers, particularly Noel, who is the, so to speak, Fonzon Arago of today, and who gave a superb lecture, clarifying and elaborating important points about human rights, which I'm sure everybody here is interested in this topic, but many of those points, they will not have occurred to them, and we all, I think, leave feeling much better informed, I think wiser too, perhaps, given the ways in which the debate was conducted. I'd like to thank also Professor Brick for a fascinating talk on particularly a rich one coming from Poland. And George, we at the Danube Institute rely on you a lot to turn up and to deliver marvelous responses to lectures, as well as occasionally giving them, and I want to do so again today. So you came, I think there are about 70 people. We haven't lost many. It's a warm afternoon, it's sunny outside, and you've all shown, I think, staying power, because staying was extremely interesting and a lot of fun as well. So many thanks to the three speakers, many thanks to you, and I look forward to seeing you after the summer when we will start our program again. Thank you.
Very good.